We have bombshell news right now. Minutes ago, the United States Supreme Court declined to hear Ghislaine Maxwell's appeal of her sex trafficking convictions from the Southern District of New York. This was one of the most closely watched petitions of this Supreme Court term because Ghislaine Maxwell argued that a non-prosecution agreement between Florida prosecutors and Jeffrey Epstein prevented her criminal prosecution in the Southern District of New York. If you recall, Jeffrey Epstein was first arrested for sex trafficking related charges. After he died in prison, prosecutors under the Trump administration actually then went and arrested Ghislaine Maxwell at her ranch in New Hampshire. She was then tried and convicted in the Southern District of New York on sex trafficking related charges of multiple women. And her primary argument leading up to that criminal trial was that a non-prosecution agreement entered into between Jeffrey Epstein and Florida prosecutors prevented her criminal prosecution in New York. She argued essentially that the agreement between Epstein and Florida prosecutors would bar her criminal prosecution anywhere, including in the Southern District of New York. And a Second Circuit Court of Appeals rejected her argument, and now the United States Supreme Court completely denied even hearing her argument on the merits. When the Supreme Court considers cases, it's not automatic. Remember, tens of thousands of cases every year go up in front of the United States Supreme Court. The Supreme Court only actually agrees to ever hear about maybe 100, 120 if they're lucky each term. It's a very small amount. And they only hear cases involving, for example, circuit splits, when one circuit disagrees with another circuit. They hear cases of novel issues of law. And actually, many legal experts thought that Ghislaine Maxwell had a somewhat of a decent shot at getting Supreme Court review here because it is a novel issue whether this non-prosecution agreement in Florida would bar her criminal prosecution in New York. And when the Supreme Court considers cases, it's called a petition for writ of certiorari. The Supreme Court then needs 4 justices on the court to agree to hear the case. If 4 justices agree out of the 9, then they'll put it on the docket where they'll discuss the merits of the case. You'll have more briefing. There'll be oral argument in front of the justices, as you hear often, starting this month. Well, here, this morning's orders came out, and United States of America versus Ghislaine Maxwell was on it. That case was decided not to be heard, meaning that 4 justices on the Supreme Court agreed or did not agree to hear the case. And so it'll never even get to the merits stage. They'll never even discuss whether the merits of the case are sufficient to overturn her conviction. A lot of people were nervous. A lot of people were scared that this could lead to Maxwell walking free from the FPC Bryan facility in Texas. But this isn't the end for Maxwell, because many were reporting that the Justice Department was reviewing what this United States Supreme Court was going to do. Mind you, the Trump Justice Department actually said that the Supreme Court should not review her conviction. So they were against Maxwell here. But the Justice Department and the Trump administration were likely waiting to see what the Supreme Court did before deciding how to move forward on whether or not to commute Maxwell's sentence, to pardon her, or to seek any sort of relief for her, because she had been cooperating with the Trump administration, met with Deputy Attorney General Todd Blanche, etc. And it comes at a very difficult time for this administration. So now the Trump administration may soon decide, well, we may pardon Maxwell, we may commute her sentence. Or now they may say, you know what, we have all the leverage in this case now, because Maxwell is facing the possibility of serving likely the rest of her life in this prison facility if she does not receive some type of commutation or pardon. And so the next steps here are the Trump administration will review whether or not she would get a pardon. But even setting that aside, it comes at a critical moment for the Epstein files discussion. Because right now on Capitol Hill, there are 217 signatures to release the Epstein files, or to force a vote to release the Epstein files. They need 218 signatures. Adelita Grijalva, the congresswoman-elect from Arizona's 7th Congressional District, would be signatory number 218. And Mike Johnson and House Republicans do not want to swear her in because they don't want to give the votes to the Republicans and Democrats. It's a bipartisan discharge petition to release the Epstein files. So here's where we're at. We're in the middle of a government shutdown. The Supreme Court still works during a government shutdown. They're essential employees. They're still going to hear cases. They're still, not the entire federal judiciary, but the Supreme Court will. Remember, the rest of the federal judiciary could theoretically shut down as soon as October 17th because it'll run out of funding, which will cause mass chaos across the judicial branch. But anyways, the Supreme Court will continue to hear cases. Now, it's rejected the Maxwell appeal. Now, there's more pressure on Congress to force the release of the Epstein files. We're in a government shutdown. House of Representatives were supposed to come back this week to potentially vote to get us out of a government shutdown. But Speaker Mike Johnson delayed that, sending them home once again for a week until October 13th. So we're now at least 1 week away from Adelita Grijalva being sworn in, 1 week away from getting the 218th signature on the Epstein files discharge petition, 1 week away from getting survivors of Epstein and Maxwell's horrific crimes more closure. We're still a week away. And even then, once you get to 218 signatures, that's far from over. Because then you still need to have a full vote of the House of Representatives, a full vote of the United States Senate, and then Donald Trump needs to sign that resolution into law. So there's still a long way to go here. But what we do know is that Maxwell will be remaining behind bars unless Donald Trump takes action to pardon or commute her sentence. And truth be told, that's a very bad political move for him. If I had to predict, Donald Trump will not commute her sentence, will not pardon her, because if he does, it'll show that he is trying to hide something, given his relation to Jeffrey Epstein, his relation to Ghislaine Maxwell. Remember, when Maxwell was first arrested, Trump was president. And when asked at the press podium what he thought about her arrest, he said that he wishes her well and had no further comments. Now, Maxwell, in her conversations with Deputy Attorney General Todd Blanche, has long said that Donald Trump did not engage in any inappropriate conduct as it related to Jeffrey Epstein. But many pointed out that Maxwell has a history of lying. She was charged with perjury. And while she would lie, any person would lie, to try to get a favorable outcome on their case, to try to get out of a federal prison. She's facing 20 years in federal prison. She's only served a couple years. She has a very long way to go here. And federal prison, whether you're in the FPC Bryan camp or in Tallahassee or wherever, these minimum security facilities may be minimum, but they're not cozy, comfortable facilities. So she wants to get out. The Supreme Court won't let her out. We'll see what happens next. This is a story that I'm going to keep front and center. So please make sure to subscribe, like, comment, share this video so that more people know. And I will continue to keep you updated every step of the way because this story matters.